Can start.
Hi, good morning, good afternoon, ladies and gentlemen. My name is David, D-A-V-I-D. I was and I still am a plaintiff in a civil action going on in the United States during the last 37 years. 37 years. The caption of this video will be "The Fate of the Dreamers who came to America through the front door." I am going to explain what it is. Recently, as you have seen from the television broadcast and other things, other media, there's a fight going on in the USA between the Congress and especially the Democrats against President Trump, who is a Republican. Trump wanted to create a wall so that illegals won't enter the United States. The people from Mexico mainly wanted to come to America because it's a rich country where people can make their lives better. So is the people from all over the world. They want to flood America. So they are called the Dreamers. Now here I am going to explain to you the fate of the Dreamers who came not through the back door but through the front door in a plane, admitted legally, and who became citizen of the United States. So the things that I'm going to discuss here is the fate of the Dreamers who came to America through the front door. Front door, not back door, like the Mexicans and other illegals who want to enter the United States, and President Trump wanted to create a wall so that they don't jump the border. Now, I've got a few things to discuss here so that you will understand what I'm going to talk to you about it. Many of you may not be lawyers, you don't understand, so I wanted to talk to you in the simple layman's language. Every civilized country in the world, they have 3 branches of the government. 3 branches. Whether in India, England, America, Australia, name it. Every civilized country. The 3 branches of the government. One branch is called the legislative branches. Their role is to create laws for the benefit of mankind. The other branch is called the administration. The third branch is the judiciary. All these 3 things put together constitute the government of the country. For example, we have Lok Sabha, Rajya Sabha. They make laws. Once they pass the laws, it goes to the president to sign, and once he signs, it became the law of the land. So it's the case in America. The US government, particularly the legislature, passed several laws to eliminate discrimination in that country. One of the laws passed by the US Congress was Title 7 of the Civil Rights Act. That was amended so many times to add new things. So Title 7 of the Civil Rights Act. This act says you cannot discriminate between a black and a white, a Chinese or an Indian or Pakistani, between men and men, between men and women. There should be no discrimination based on national origin, color, gender, sex. These are the basis laws passed by the US Congress and signed into law by the President. So they are on the books. Second issue is whether any of the employer, for example, violate any of the laws. The aggrieved party has the right to go to the court to tell the court, the employer has violated my rights under the law, so seek redressal. That is through the judicial system. So finally, we have to accept whatever the judiciary says or interprets the law to be. Regardless, there may be opinion among experts, legal scholars, what the Congress intended, what the administration is doing, or the agencies within the administration. The second law passed by the Congress of the United States is called discrimination based on age. Age discrimination is called ADEA. ADEA stands for Age Discrimination in Employment Act. That is another law passed by the Congress, which says an employer cannot get rid of an older employee and hire one or two small young kids or young persons to replace him, because this old man or the senior person may be making over the years a lot of money. So they can get rid of a senior person and hire one employee to replace him by terminating his services illegally. That is a violation of the ADEA, Age Discrimination in Employment Act. Then the Congress passed another law. It is called ERISA. ERISA stands for Employees Retirement Income Security Act. That act says if you work for an employer for a period of time, the employer has to pay you compensation or a sum, at the end of your employment. That's the third law. There are so many laws passed by the Congress. I am concerned here with these three laws. That is Title VII of the Civil Rights Act, Age Discrimination Employment Act, and ERISA. These are the benefits denied to me by a mammoth corporation in America. Now, let's go into the merit of the case here. When I was working for one of its subsidiaries, known as Michigan Bell Telephone Company in Detroit, Michigan, as a clerk, upon my arrival from Britain, as a citizen of that country, these guys found me way overqualified, my immediate supervisors. I didn't know they were watching me remotely, and they were checking my punctuality, work habits, a lot of things. I don't want to go into that. They found me on their own, not my asking. After 6 months of my employment, they found me way overqualified. My boss called me for an interview and spoke to me highly about my credentials, my experience, my knowledge, and my punctuality, everything. He wanted to promote me. I didn't ask them. He wanted to. He asked me what skills you have. I said to him, I used to work in India for a new India insurance company, one of the major insurance carriers in that country. I also happened to work for the Chief Justice of the Indian Supreme Court, retired Chief Justice, at his home where I was in law school. I told him I also worked in the British Post Office, where I had received 2 commendations from the British government for catching a bunch of crooks. And I got cash awards and commendations. It was in their magazine and everywhere. These are my background, which I explained to my boss. Oh, Mr. David, you got good qualification, good criteria. What job do you think you are qualified for? He wanted to offer me a management job. So I told him I used to work as a secretary in my law school days. Oh, you wanted to be a secretary? We have 600 secretaries, all are female, so you want to be the first male secretary. I said, fine, sir. He said, it's a management job, good pay, well-paying job. I was tested for 3 hours, which I finished in 1 hour. I was sent for an interview with the person whom I am going to work for. He says, no, I don't want a man as my secretary. I always had females. You understand the situation here? I was working satisfactorily. The management on their own motion asked me They promoted me, sent to work for this guy, he doesn't want me. But the central personnel insisted you take this guy because he is qualified education-wise, experience-wise, and test-wise. He had no option but to take. He wanted young girls for whatever purpose you can, assume. Within 3 days he said, no, you are not fit to do my job. He sent me back to the department I was working. I filed an EEOC complaint against the employer. EEOC stands for Equal Employment Opportunity Commission, created by the US Congress. They came and investigated, found the employer guilty of sex discrimination, gender discrimination, ordered the company to reinstate me and pay me compensation, which is a nominal amount. The employer complied with. I was sent to work for a German, a French, an American black, and an American white. All of these guys found me again way overqualified. It's not my fault. I didn't tell them, they found me. My last manager, who was an American white, he said, Mr. David, there are 2 ways to get promoted within the company. One is you nominate yourself, or I recommend you, so you go for the interview, which is a 3-day assessment of your skills. They watch you remotely, they hear your discussions remotely, they may be sitting 5 miles away. That's just technology. I got a highest score in that competitive test. But the company will not reveal the test result for over 1 year until I demanded them to disclose. The personnel officer came to me and said, Mr. David, you got a highest score. That doesn't mean you are promotable. You are never promotable. He said, never promotable. I don't have any criminal record. I have no record. I don't even have a parking ticket. You have to understand, somebody living in America don't have, at that time I'm talking, I had subsequently later on, when I went to work for the court system. Parking ticket, you have to go and put money in the meter, and then when you came back, you are out of time, so they give you a ticket. Other than that, I had nothing. So, I asked him, is it because I filed an EEOC complaint? So he was keeping quiet. Meaning, that is the reason why they don't want to promote me and send me for 3 years of intensive management training, as was done in the case of blacks and whites and everybody. I was forced to file second EEOC complaint for retaliation. Before they started investigation, AT&T, Michigan Bell, immediately promoted me and sent me to work for AT&T, which was their then parent company, to Orlando, Florida, from Detroit. I was one of 1,500 employees recruited by them to defend them against the Department of Justice, who had brought an antitrust case against AT&T. The terms and conditions, you have to understand the background here, stated that we will work for AT&T for a period of 5 years. Afterwards, the company, the original company where I was employed, Michigan Bell, they have to take me back. They had sent also 60 employees from that company, Michigan Bell, to AT&T. And we were a team of 1,500 people working on the defense of various cases. One fine morning, the US Department of Justice and AT&T agreed for the mutual breakup of these companies because there was no competition prior to that. And under the American law, there ought to be competition so that the people get best products at reasonable prices. But if it is a monopoly in the hands of a monopolist, they can keep raising the prices, they don't care about the service. That's the intent of the Congress. I didn't pass the laws, US Congress. So AT&T and US Department of Justice agreed mutually to settle the case, and then AT&T agreed to be broken up into separate segments, each company competing against the other. So we were part of it. I was the only person of Indian origin in their legal department, one Kerala guy, one Indian guy, sole person in the legal department. There may be people in other departments. I was called by my division manager of Michigan Bell, called for a meeting, and they offered me, Mr. David, here's a check for you for $35,000. Quit the job. I said, I don't want the money, sir, because I've got small children, then aged 3, 7, 9, 11. My youngest boy, he was 3 years old, he's a doctor now, and others are in different fields, well-settled positions. Now, at the time, I was a sole breadwinner in the family. I had 4 children by then. My father, my dependent father, my wife, who is a nurse by profession, she was taking care of the babies. So I said to the man, look sir, I don't want to leave the company, I don't want to quit the company and take your $35,000. So we left. I left for my home. He called me again that night. He said he wanted to see me along with my wife at a hotel lobby where I went for a meeting with this guy. He said, we'll give you $45,000, Mr. David. You want to take it or leave it? Let me know. I will come back in 5 minutes. When he came back, we told him, sir, we don't want the money. Then he says, you're fired. You are fired. For now. For what? During the period I worked for AT&T, they had given me every 6 months a merit increase, and the last merit increase of $5,000 was given to me on Monday morning. Friday, I was fired. For what? There is no legal basis, no reason. It's a discrimination because of retaliation, my previously filing two charges against them with the EEOC. That is not a legal basis to terminate an employee who had received merit increases and a fully satisfactory job performance rating for 2.5 years. I worked for AT&T. Folks, you have to understand this is the background without which you won't understand the legal issues now. I filed the 3rd complaint against them. I asked the employer, sir, pursuant to the agreement, you have to pay me, you have to buy my home. I had a fully air-conditioned 5-bedroom house with a swimming pool and everything, like most Americans have. And they were supposed to sell the house, pay me the market price, as appraised by 3 independent appraisers, which they don't want to do. They had offered other employees the $1,500, 3 years salary if they want to quit, any of them wanted to quit the job. 3 years salary. It's a golden handshake. They didn't offer me that. The options given to the other employees were either go back to the companies you came from or go to another company within the system. They didn't give me any of the options. They didn't allow me to go back to the company I came from. They offered me the money, I refused. I was fired illegally in violation of the laws passed by the Congress. I was at the time over the age of 42, so the age discrimination laws came into being because they are firing somebody who is over the age of 40 and retaining younger workers. You understand the name of the game here, the facts here. Now, they literally held me and my 4 small children and my dependent father to economic ransom and blackmail, refusing to comply with the terms and conditions of their agreement. I had no option, because if you don't get paid, like the federal employees who are kept furloughed by the Trump administration, if you don't get paid, either on Friday, management gets paid every 2 weeks, you have out of luck. You have to pay mortgage, car payments, bills, whatnot. They know my situation full well, this employee. They refuse to pay any of the benefits due to me under the contract. You understand? It's a breach of contract. I beg them, resolve this matter, reinstate me, you made a mistake. No, Mr. David, you are fired. For what? What crime did I commit? In order to fire an employee, you must have done something wrong. Here I am getting a merit increase on Monday morning, $5,000, semi-annual merit increase. Every 6 months I get a raise. Understand? And they gave me a fully satisfactory job performance rating. So there is absolutely no basis to fire me. And Florida is not a free will employee state. An employer can hire and fire as they please. AT&T is a major corporation with 1.5 million employees then. They can single me out and fire. I moved to the court, pro se. The case was assigned to John A. Reed Jr., who is dead now. On April 7, 1983, Judge Reed denied the defendant's motion to dismiss the case. Because AT&T came up and said, Mr. David signed a release, it is valid, it should be accepted, and he resigned the job. Folks, when you sign a document under duress, if they bring a gun and threaten to shoot you, is it valid? No. Here what they did, worse than that. They failed to comply with the terms and conditions of their agreement. As a retaliation, they didn't do any of the things while offering the other employees, 1,500 employees, all the benefits except me. The judge, John Reed, as I told you, issued an order denying the motion to dismiss. Because AT&T and their lawyers came up with an argument, Mr. David signed a release which says he quit the job. Did I quit the job? After my termination, illegal termination, I went and picketed in front of AT&T along with my children and my father, who is dead now too. It was on prime time television, which said, excuse me, the little David's fight against the mighty Goliath is on Channel TV in Orlando, Florida, and in various newspapers like the Orlando Sentinel. They refused to comply. Now their defense was they made me subsequently sign an agreement, which I claimed under duress. I didn't quit the job on my own. I was fired illegally in violation of the laws passed by the Congress. The judge said in his order, which you will see, put it on, that defendant's motion to dismiss the case is denied. The court will conduct a hearing to determine the validity or otherwise of the release in a trial, in a hearing. He wanted to conduct a separate trial within the trial to determine whether the release is valid or not. That is the contention, that is the order of the court, which you have seen now. For during the last 37 years, that bifurcated trial with regard to the validity of the release never took place, 37 years. Why? The defendants could not prove what they are saying is true, but they have to convince the jurors that Mr. David, a man with 4 children and his father and wife, quit the job and took the money. They have to prove it. According to the U.S. Supreme Court, in a case called Alexander versus Denver Gardner, the burden is upon the employer to show the employee quit the job on his own, freely, voluntarily, and knowingly. That's started, cited by the Judge John Reed of the Orlando District Court in 1983. The defendant tried their best to prove it. They failed, utterly failed. I had hired at the time an attorney from Chicago by the name Syriac D. Capel. He was subsequently murdered. They tried to give him a judicial position which he declined when I was sitting in his office. Then they tried to bribe him by giving him more cases which he declined. Then they threatened him saying that they are going to make this case expensive so that he, being a solo practitioner, he won't be able to spend the time required. Okay, because I had to pay him flying cost, his time spent, hourly rate, which I can't afford. So I terminated my counsel. He was subsequently murdered. Defendants conducted 3 days of my deposition, 3 full days. They conducted a deposition, but they call it is not in the court, it's in the private office of the lawyer. There will be a court reporter, she will be taking down the answers or responses provided by me and their questions. That's how it is done, the deposition upon oral examination. They call it in the state court EBT, evidence before trial. In the federal court they call it deposition. Doesn't matter what the name it is. But when I asked discovery, this is what is called discovery process, they won't give me anything. Everything I asked, beyond the scope of the court's order. You understand? In a game, in a proper game, both parties are to be given discovery pursuant to the federal rules of civil procedure. AT&T won't give anything. And what happened, you have to understand the background here, folks. They secretly hired the judge's close friend and his former law clerk, a woman by the name Anne C. Convey. You see her photo here. So she was meeting this judge at his home, the opposite party's lawyer, going to see the judge at his home, maybe with a trunk, briefcase full of cash. They can give check because there will be a record. So she was meeting him, he was meeting her at her home. They were meeting in Atlanta, other places. This was confessed to me by the judge in response to a questionnaire I sent him. He called me on the phone, a sitting federal judge calling a non-attorney to his home. Have you heard of that? A judge cannot even call a lawyer who is licensed to practice. They can meet in the court, open court, in the presence of the other parties. Here, this woman was used by the defendant to influence Appellate with the judge and to avoid conducting a trial as per his order, dated April 7, 1983. I began to become fishy because the judge will call us for a conference, nothing in the open court, everything in his private chambers away from public scrutiny. I became fishy, suspicious of what is going on. I didn't know the connection between the judge and this woman. I sent the judge a questionnaire consisting of 20 questions for him to answer. As soon as he got it, he called me on the phone. Sitting federal judge calling me, a little guy, from Orlando Federal District Court to New York, where I was staying with a friend of mine. He said, Mr. David, I got your questionnaire. I am not going to answer that in writing, but I will give you answers over the phone. Sitting federal judge calling me, I didn't call him, he called me, and is telling me he will give answers to my questionnaire. I said, Your Honor, I need to tape record our discussions so that I have proof what you said is true. So after consulting with his people who were there in the courtroom or wherever he was calling me from, he finally agreed. He said he was meeting this woman at her home. She was meeting him at his home. They were meeting in private in Atlanta. You have to understand, a lawyer representing the corporation meeting the judge in private. The reason is, if I prevail on the merit in a court of law, the defendants have to pay me millions in damages and costs and back wages and benefits. They can avoid this by bribing the judge. The judges those days made $72,000 a year salary, which translated to approximately $1,500 a week. During the telephone discussions, Judge John Reed also admitted that he was a shareholder of AT&T, which is not very serious, but it's an admission, because he is now dealing against the company of which he is a shareholder. He was also a lawyer employed by AT&T in one of their subsidiaries called Southern Bell Telephone Company. Before he became a judge, he was a lawyer there. So we have serious conflict. In addition to the fact that he was meeting the counsel for the defendant at her home and other places, which is a serious violation of the canons of ethics. He was telling all these things. This woman used to work for the judge at the Middle District of Florida for 3 years. These are all prejudicial information the judge and this woman should have disclosed to the other party. I am conducting my own case. I don't have a lawyer, because lawyers don't take cases against AT&T, because every lawyer handled with this corporation know very well how to screw them. So lawyers don't take cases, especially employment discrimination cases. As soon as judge revealed this startling information, I reported him to the FBI, Federal Bureau of Investigation, and I also complained to the Chief Justice then, Honorable Warren Burger of the US Supreme Court, asking him to take appropriate action, because this judge is not a straightforward judge. You understand? So, as soon as Chief Justice Warren Burger got this material, this complaint, he apparently ordered him to resign. Judge Reed immediately recused from the case and resigned from the bench. He went to work for another law firm as his partner, to where AT&T is sending 1,500 retiring relocating employees cases. A firm called Drostic, I don't have the name, I have it, but I can't remember, by heart. Drostic Kander or something in Orlando. So the judge recused, resigned from the bench. So what you are supposed to do, this is a courtroom, there are 6 judges in the court. If a judge dies, retires, becomes ill, the case has to be reassigned to one of the judges in the same court, which they don't want to do. They were shopping around which judge they can transfer the case to. I asked the court to transfer the case to New York, where I am living, and the AT&T had their corporate headquarters there. They don't want to. They transferred the case to a buddy of this judge, who is equally corrupt. The players are all corrupt. They are all gangsters in the whole scheme. So a case was sent to Tampa before Terrell William Hodges. You see his picture here. Another one. Terrell William Hodges. Terrell William Hodges issued me an order directing me to come from New York to Tampa, although the court at Tampa had no jurisdiction over me. You can only ask somebody to come if the court has jurisdiction over me. I never lived in Tampa, which is about 80 miles away from Orlando. Why should I go there? But it being a court so remanded, On the notice board, the judge has mentioned additional security required, no other hearing today except Mr. David's. I am not a wanted criminal appearing in a criminal court of law. I am a civil litigant seeking an ounce of justice. Why this judge is so much afraid of me? I am not a wanted terrorist. I am an ordinary simple American with no parking ticket even to my credit. When I went there, the FBI agents one side, marshals on the other side, local police on another side. I'm sitting before the judge, guarded by these people as if I'm a wanted criminal. You have to go through the metal detector, they check you whether you have any weapons, even a pin in your pocket. So the judge says, no, I am the chief judge and I can conduct these proceedings and I am going to do it in accordance with the rulings and parameters as decided by Judge Reed. He refused to transfer the case to New York for obvious reasons, because no judge should have a vested interest in the outcome of a case. If you have no jurisdiction, you can't conduct a hearing there. No personal jurisdiction, no geographical jurisdiction. He insisted he will do it. Did he conduct the hearing, folks? No. He was playing into the hands of this corporation. In the meantime, it's all under the table deals with the judges. We think they are honest, honorable. They are not. They are a bunch of crooks. This goes from one crook to the another crook, which is a super crook, and goes to another super crook. Once you hear me fully, you know what's going on. In the meantime, AT&T fired, the Michigan Bell fired another employee who was a division manager, paid him $12,000 as compensation. And that guy's name is McDonald. He was a division manager working for AT&T in their New Jersey facilities. Under the scheme, this guy files a state action rather than a federal action. There are two courts. One is a federal court, one is a state court. So he goes to the state court in Michigan, and Michigan court says, Mr. McDonald must first tender back the money. As soon as the court renders a decision, my case is kept in abeyance without doing anything until they hatch this case and bring its decision. As soon as the judge issues an per priam unpublished order and opinion, they hastily get it the same day it was rendered. You know, everything is working with the mathematical precision where you can put the money, pump the money. This counsel for AT&T, Miss Conway, and Pete Cinnabar, he was the lead counsel, they filed a motion in the court before Judge Hodges, telling the court, we don't have to conduct a trial with regard to the validity of the release. The Michigan law says he should tender back the money, so Mr. David should be required to tender back the money back to the employer before he can commence the action. This is 3 years after I was illegally terminated and paid me the 45. And you know, when you spend the money, money's gone. You have no way to tender back the money. But the Supreme Court says another case, which was decided later on, and the name of the case is Aubrey versus Entergy, 1998, I believe. In that case, the Supreme Court of the United States says, you don't have to tender back the money to the employer first. You can pay that once the case is settled or adjusted. The amount can be adjusted. But this judge don't care. He issues an order, a 5-page order. I never met the judge after the first meeting. Before granting a motion for summary judgment, there are procedural requirements which are well laid down by the US Supreme Court in 3 cases decided by in 1986. The trilogy of the cases, the standard for granting a summary judgment. The judge says, hell with the Supreme Court, I decide my own way. He issues an order, getting the facts from his hat. If you don't have it before the judge, you never went there except for the first meeting, how he gets the facts of the case? So he makes up his facts his own way, okay, without any hearing, without any discovery, without any information from me, based on what the AT&T and Michigan Bell told him. He makes out a story. You understand? The judge makes out a story. How can a judge make a decision without hearing the parties? It's a one-sided decision. He issues an order, and at the end he says, if Mr. David didn't tender back the consideration to the employer within 10 days from the date of this order, the case will stand dismissed without prejudice. Without prejudice is a technical term. Many lawyers, including the lawyers I spoke to, I worked subsequently and before, they didn't know the difference between a dismissal without prejudice and a dismissal on the merits. The judge's order was changed by the clerk, a clerk by the name Donald Brown. Judge issues an order, clerk changes it, and he makes it, case is dismissed on the merits. On the merit means the parties were heard, submitted witnesses, documents, everything. Here nothing has happened. The circuit judge never saw me after the first meeting. So there was no decision on the merit. So the clerk of the court, deputy clerk Donald Brown, changed it to suit the defendant's purpose for money. He was doing this for a period of time. Two judges reported this guy, Donald Brown, as incompetent. He was fired from the court, which I can know later on. So now the question is, you have to go to the next court, because once the lower court rendered a decision, you have to go to the appellate court. So according to the judge's order, it's a dismissal without prejudice, which the clerk of the court altered. You understand? So the defendant's attorneys are qualified to practice before the US Supreme Court. Pete Silver and Conway and another woman who are on board, one woman. So you have to understand the gimmicks here. Now, under the rules, the Court of Appeals, in this case, 11th Circuit Court of Appeal, their clerk is required to see whether the decision is appealable or not. That's his job. The US government, the judicial, the administration have put out so many videos explaining all these things. They cited New York courts and lot of courts, and they said, but the court has no jurisdiction, it cannot hear the case. Okay? And the clerk of the court is required to examine whether the case is appealable or not. The judge's order was non-appealable. So this Columbia and the Yale graduates, and Sinabar is not a Columbia or Yale graduate, but he is qualified to practice before the Supreme Court, and Anne Conway, they filed a false jurisdictional statement. You will see it here. They filed a false affidavit, a jurisdictional statement, saying the Court of Appeal for the 11th Circuit has jurisdiction to hear the case under USC 28, section 1291, 28 USC 1291. The section says the Court of Appeal has jurisdiction to hear a case if it is a final decision, not an interlocutory order as here. So the clerk ignored the clerk of the court, and in the Court of Appeal they had at that time, I believe, 29 judges in the United States Court of Appeal, I can't count now because, past event. This case goes to a panel of the defendants choosing. You understand? Case is fixed at the court below between the judges, the clerk. Now I go to the US Court of Appeals. It goes to 3 crooked judges, which I came to relate to. They, without examining the court has jurisdiction or not, accept the case, issues an order of affirmation, affirmed, one word. I was given 5 minutes time to argue before the Court of Appeals in Atlanta. I had to fly from New York to Atlanta for a 5 minutes hearing. They put the button on, the green light. 4th minute you get the amber, 5th minute you are cut off. I told the judges, Your Honors, I have 6 legal issues to be argued. The 5 minutes time is inadequate. They said, no, Mr. David, we will read your brief. They affirmed. Of the 3-judge panel, 1 judge was bombed and murdered by another litigant, a person by the name Moody. I can't remember his first name now, Mr. Moody. He was executed last April by the federal court, by orders of the federal court. That's a hotly fought case. The guy is a rich man, he had his own plane and everything. He had some issues which they don't tell us because they don't want these things to be known to the public. So this guy prepared a bomb in a box, put the from address of another judge, sent it to the judge. He opened up, he's blown. He's gone, the federal judge. His name is Robert Vance. Yeah, anybody wants to check it in the Google, YouTube, Robert Vance. The second judge took a gun and shot and killed himself. His name is Clarence Allgood. Okay? 3-judge panel. Don't ask the questions. The court, you don't get the information, it's not top secret. Why he did what he did with his own gun, why the other judge was bombed and murdered. The 3rd judge is a black, American black. He is amenable. Under the table, you pump it, he will do everything you want. So, what happened was, I'm losing track here. Okay, so these 3 panels, these are the 3 judges who affirmed. I moved to the US Supreme Court with a petition called petition number 86, 6168. I will double check, 6168, is that right?
62?
No, 6168. Hold on a second. Well, I moved to the Supreme Court. The Supreme Court, before the US Supreme Court, the Defendants Council says the order of the court below, that's the Tampa court, is a temporary order which can change any time. Therefore, the Supreme Court has no jurisdiction to hear the case. You understand? They are telling the 11th Circuit it has jurisdiction, the intermediate court, that's Court of Appeals. They're telling the Supreme Court the court has no jurisdiction because the order of the court is an interlocutory order. You understand how they bluff? The lawyers lie and bluff the Supreme Court of America. So the certiorari was denied by the Supreme Court on the basis of the false submission of papers. Okay? They cooked up everything. They think they are smart, other Indians, they don't have the brain. Okay? That's their thinking. They haven't seen the bright people. They will see soon. Now, Supreme Court denied certiorari. 5 years later, when I was working in another law firm in New York, I happened to read the law journal. I found out the difference between a dismissal without prejudice and a dismissal on the merit. Some vast difference. Ordinary lawyers, they don't know, ask them. Any one of them, if you know, ask them. What is the difference between a dismissal without prejudice and a dismissal on the merit? So, I immediately wrote a motion, I filed a motion before the first judge, this guy, Terrell William Hodges, telling the court, Your Honor issued an order to dismiss the case without prejudice, which the clerk altered as a dismissal on the merit, and that's how the case went on appeal, so amend it. So Judge Hodges had no option but to amend the order, saying the clerk made a clerical error. It's a clerical, it's not a clerical error. You understand? You pay the money, so he changed to suit their purpose. That's the game of the plan, the name of the game. So Judge Hodges issued a second order on January 13, 1991. January 13, 1991. You will see a copy of the order. Amending the judgment. Okay? So, what the clerk did was change the judge's order. Now judge says clerk made a mistake. Now is the case appealable? No. The Court of Appeal can only hear a case from a final decision. Judge Hodges' first order and the latest order, dated January 13, 1991, is to dismiss the case without prejudice, which is unappealable. You understand the name of the game here? So, I moved to the the Court of Appeals. So, as I told you before, there were 29 judges in the Court of Appeals. This case only goes to J.L. Edmondson only. J.L. Edmondson had ceased himself to be an active judge, a retired judge from that court as from 2012. He cannot even hear. He is not one of the active judges. I filed a motion. They call motion, in India we call application or petition. In America they call motion. I filed a motion under Rule 35 of the Federal Rules of Appeal Procedure, FRAP 35, seeking the en banc hearing. The entire court should hear the legal arguments, because the court had erroneously accepted the case, rendered a decision which was affirmed by the panel previously. Now we are telling the court, hey, you made a mistake. You can't have jurisdiction to hear the case. So this judge, out of the 29 judges, this case goes to this black guy, J.L. Edmondson. He's a retired judge. You understand the name of the game? The Federal Rules of FRAP 35 says the motion should be heard by at least 3 active judges. Not a retired judge, active judges. So this guy is no longer an active judge. He ceased. First of all, he made a mistake in accepting the case in 1985. Okay? Now we are telling the court, he says, the petition denied, my motion denied arbitrarily and capriciously. When the lower court says we made a mistake, why not to vacate the order, the mandate, which he doesn't want to do? You understand? I filed a second motion. He directed the clerk of the court not to accept any papers from Mr. David on disclosed file. That's his order. You will see a copy of his order. I filed a second motion seeking, the Federal Rules of Appeal Procedure says, you have to cite so many things, and this is how they should begin the motion, which I did. I sent them 15 steps of my motion, addressed to the court. It goes back to the same judge. You understand? The name of the game. It doesn't go to the honorable judges, independent judges. It goes to the judge to whom AT&T funnels funds. I mean, I have no proof, but you can assume if you have brain. You understand why this case goes to a judge who is a pro-corporation judge, and he's doing everything in violation of the law. Because the lower court said we made a mistake. So if he made a mistake, they have to recall mandate, which he doesn't want to do. Folks, now I move to the US Supreme Court. Telling the Supreme Court, this court had no jurisdiction to begin with. The 11th Circuit Court of Appeal, I cited so many cases decided by the US Supreme Court in the past, and also the decision of the 11th Circuit. When a court had no jurisdiction, its judgment is a nullity, legal nullity. Now, people have to understand, listen to me please. The name of the game in the Supreme Court of the United States is, they only pick 80 cases. 80 cases. It's like a random, or they call it random, or based on the questions presented. There will be always, or at least for the last few years, more than 10,000 cases filed in the US Supreme Court. And do you think that 10,000 cases are being read by 85-year-old Judge Ginsburg and other people who are in the over 80s? Or the younger lawyers, judges? 10,000 cases is humanly impossible. So, under the scheme, you have to understand, this is all well researched. This is what I've been doing last 38 years. Researching, finding out the facts, the truth, to get the truth. I'm a fighter for justice. The world will realize me after maybe my time. We are making a movie on this. I'm speaking currently with a lot of producers to expose the corruption within the US courts. So, Supreme Court allegedly denied. I am telling the court, citing the cases decided by the Supreme Court, telling if the court has no jurisdiction, its judgment is a legal nullity. No effect can be given. Well, in my case, I'm not a Jewish gentleman with a feather in my cap. I'm an ordinary simple citizen. I'm telling the court to do the same thing. They said, hell with you, Mr. David. The justices do not understand what is going on. Because the scheme is pick and select 80 cases only out of the 10,000. So 9,920 cases go unheard regardless of their merit. You understand the name of the game here? The justices don't see. It's all being controlled by the clerk of the court. That's where I'm coming to in a second. Now, I filed the petition in the Supreme Court, case number 15-9100. Certiorari denied. The justices may not have even read the story, the facts. Denied. Other cases they say granted. Because the court had no jurisdiction, its judgment is a legal nullity. So many cases, not one or two, so many, I cited all of them. And the 11th Circuit Court of Appeal did likewise. But the justices there, the judges there, Supreme Court, they call justices, in the lower court, judges. The judges in the 11th Circuit don't read my papers, they don't get it. It only routed by the clerk to the judge whom they want to have this case decided. The name of the game. You understand the scheme here, those who have the brain to understand what I am talking. I'm not an insane person, first of all. Okay, I'm well educated. I studied in America also. I went to Wayne State University, University of Detroit. I'm not going to go into my qualifications, but I have the brain, although my faculties of thinking failing. I'm at the age of 79. So, Supreme Court denied certiorari, case number 15-9100. No reasons given, denied. I think one of the orders, I don't know, they said my claims are frivolous and malicious. Frivolous means silly, malicious, because I'm exposing the judges. You understand? So then I filed another petition before the Supreme Court, case number 16-9624. Supreme Court, if you go into Google it, you get the Supreme Court, you can search the docket. 16-9624. In that order, apparently luckily some of the judges might have read it or had reasons to believe what I'm saying. So when I filed the petition, I was only making a small pension from the US government. I'm not getting pension from my employer, which they were supposed to pay me maybe around $3,000 a month. They don't want to pay me nothing. Okay, this is a crooked, the mafia corporation I've seen in my whole life. Their tactics, stings all around the globe. I want the people around the world to watch this. Okay, so they give me no pension, although I worked for them 8 years. I got no benefits, no pension, no back salary, no nothing. Okay. Now, in this case, number 16-9624, which you will see on the screen, the court said, your motion to proceed in forma pauperis is denied. It means I am asking the court, I am only making X amount of money, so under the laws, I am entitled to proceed in forma pauperis, means I have no money, waive the fee, which is $300. Unless petitioner pays the docketing fee and file the petition. Folks, as soon as I got the order, I obtained a $300 check, bank draft from my bank, ICICI Bank, and sent 40 sets of my brief. I'll do 40 sets of my brief, so the brief sent to the US Supreme Court, costing me around 1 lakh of rupees for mailing alone. This high. The brief, 40 sets here. As soon as this petition was received by the clerk of the court on January 17, 2018, another clerk. See, the name of the game here is, folks, everything going through the clerk's office. This woman's name is Melissa Blalock. Melissa Blalock says, I'm reading from her letter dated January 17. Dear Mr. David, the above entitled petition for an extraordinary writ of mandamus was received on January 17, 2018. The papers are returned for the following reasons. This is what the woman says. Pursuant to the court's order of October 2, the clerk has been directed to reject your petition in non-criminal matters unless you pay the docketing fee required by Rule 38 and submit your petition in compliance with Rule 33. Also, a petition may not be joined with any other pending pleading, see Rule 112.4. This is what the woman says. What I sent to her is the petition pursuant to the rules, which the court directed me to pay and submit the brief. So this woman, she made a fatal error. On the top of the letter, here you see, in re Talakotu David, case number 15-9100, in re, mark it. So she is barking on the wrong tree. We are talking case number 16-9624, not 15, which is dismissed, allegedly dismissed. So this woman was wrong. You understand? She is reading wrong case and telling me to do what is mentioned there, which is what I have done. and she got the papers. So she sends the papers in 4 boxes back to India, costing the American taxpayer for her ignorance. She can't read English. She is titled as a legal analyst in the US Supreme Court, in the clerk's office. I am doing exactly what is done here, stated here. This stupid idiot don't understand. I tried to call her so many times to the US Supreme Court on her number, which is shown as 202-479-3023. That's the number for this woman. I tried to call her. I have a toll-free number from my back here. I can call. They can call me from America free, toll-free. I called her several times. She won't take the phone. She directed me to leave a message, which I did few times. We have a record. I can produce evidence from the vonage. She won't return my call. My purpose in calling was to tell her she is barking on the wrong tree. She is not reading, she is citing a wrong case, reading from the right case, and I complied with the same thing, she is returning the papers. What an idiot she is. I called her supervisor by the name Jeffrey Atkins. That's a supervisor. He won't answer the phone either. He won't return my call either. I was wanting to clarify the mistakes here. So I sent the letter, the check, bank draft to Chief Justice Roberts, requesting him to direct the clerk's office to accept the petition. I am complying with the court's order. So Chief Justice apparently sent these papers back to the clerk's office. They are in 2 different departments or different buildings. So I am getting a letter from Jeffrey Atkins. Says here, February 16, 2018, dear Mr. David, in reply to your letter of submission referred to this office by the Chief Justice on February 16, 2000, I regret to inform you that the court is unable to assist you in the matter you present. On October 2, 2017, the court dismissed the petition for writ of mandamus in case number 1696. This case is considered closed in this court. The papers are returned herewith. Your check is also returned herewith. So what this idiot is doing, I don't think they are idiots, because they are doing under the direction of the corporation. They have a different way of handling. Okay, they send their undercover agents, pay them the kickback in cash, so white money, that goes into their pocket. So this idiot is telling me what is in the order without reading the complete sentence. You don't read a sentence half without reading the other half, which says, unless the petition is submitted pursuant to rules and the fee paid, which is what I have done. So the second clerk in the US Supreme Court clerk's office is committing this error. Second clerk. Third clerk. First clerk is the Tampa court clerk, who is fired. Then this Melissa Blalock, she is reading from a wrong file, returning my papers. The third clerk, the Jeffrey Atkins, is telling me my petition is dismissed. What was dismissed is a petition to proceed in forma pauperis, not the petition. The court directed me to submit another petition, which I did. Folks, I wrote to the chief clerk. His name is Scott S. Harris. He is the person in charge who sees the justices of the Supreme Court every day. They have discussions, whatever it is, political reasons, which I don't want to go into. Those who know the politics in America, I don't have to explain. Those who watch CNN or the other channels, Fox News, you know what's going on now. Now, Mr. Scott Harris doesn't respond to my letters, and I am getting another letter from the same idiot, Mr. Jeffrey Atkins, So I wrote to the clerk of the court, Scott Harris, telling him these two idiots, Melissa Blalock and Jeffrey Atkins, made error. It's not an error, intentional error, mistakes. So take disciplinary action against them and review the same. Okay, I'm telling the chief clerk of the court. He is the one who meets the justices every day. He is a top official in the US government, in the court system. So he doesn't respond to my letters. I'm getting another letter from this same idiot, Jeffrey Atkins. This letter is dated April 10, 2018. You will see them on the screen. In this letter he says, "Dear Mr. David, in reply to your letter of submission received on April 9, 2018, I regret to inform you that the court is unable to assist you in the matter you present." Okay? Now I say, under Article 3 of the Constitution, the jurisdiction of the court extends only to consideration of cases or controversies properly brought before it from lower courts in accordance with the federal law and filed pursuant to the rules of this court. Your papers are returned herewith for reasons stated in January 17 and February 16 correspondence. So this is the third letter from this idiot. Now the question here is, when the court says, file the petition, pay the fee, that's the court's order, October 2nd order. This guy, being a clerk of the court, he has no legal authority to tell me my case is dismissed pursuant to Article 3 of the Constitution. So he issues a third letter. The clerk of the court keeps quiet because he knew what he's doing. Okay? So he is keeping his eyes. They are all in collusion. In collusion, the clerk of the court, Tampa, the clerk of the Court of Appeals in 11th Circuit, the clerk of the US Supreme Court, Melissa Blalock, and this guy, Jeffrey Atkins, they were all wrong. But who is to tell them? When you tell the chief clerk, your clerks made mistakes, this guy sends me Article 3 constitutional issue saying that the court has no jurisdiction. If the court had no jurisdiction, how they issued an order? How the case continued 37 years? You understand? The fraud was committed by the defendants in cahoots with the clerk of the court, with the judges. Miss Conway, going to the judge's home, meeting him, doing all the hanky-panky. Now, I reported him to the various state agencies who oversee the functions, the duties of judges and lawyers, including the clerk of the court. So they are in a quandary because I caught them red-handed. You understand? So we have an acknowledgement from all the Bar Council of Florida. I have complained against all these lawyers and judges involved. I reported him to the D.C. The Judicial Qualification Commission. Now Mr. Jeffrey Atkins used the last trick. Last trick was he allegedly sent me a letter which is dated 8/13/2018. You can see it, we will show it on the screen. You know, the bold thing. This is dated 8/13/2018, franked by the US Postal Office, paying $28.52 for postage. Now, there's a tracking number attached to this, which is LC 923048 363 US, addressed to me, to India, in this box. This was posted by him on August 10. Okay, August 10, framed on August 13. It took 4 months, 17 days to reach India. Here you see on the back of the envelope, stamped Shangugam Beach, and the date was 29/12. So it took 4 months, 17 days to reach a mail from USA to here. It's not a shortage stamp or anything, it's franked. So this was done. Now another thing, we checked the tracking number, this number. And that tracking number was shown as having been received somebody in Israel. The country of Israel. Here is a copy of the tracking number which I tracked from the USPS.com. It says delivered December 31, 2018 at 5:41 p.m. LC number LC 923048363 US tracking number. Okay? Why it took 4 months and 17 days to get me, and what is the relationship between the party who is in Israel? You understand? Now, there is a reason why. When I started complaining to the agencies, the federal agencies and the Bar Council to take disciplinary action against Scott Harris, okay, they must have asked for information. So what Mr. Jeffrey Atkins did was sending me all the papers I sent to the clerk of the court, Scott Harris, everybody, back to me. Okay? All the papers here, all the papers, all the exhibits, he sent it to me so they don't have record. They don't have record. See? This is an exhibit. It was stamped on January 17, that's my original brief, which they returned. And this was sent along with the papers to the clerk, Scott Harris. So they dated it July 30th, 2018. So once the investigation started, he got panicky. So he must have gone to the post office, bribed them to backdate this postal franking stuff to 8/13. He may have done this sometime in December, or kept this intentionally without mail. No mail will take 4 months and 17 days to reach from Washington D.C. to India. Okay? So the fraud here. They are trying to cover up their fraud, one with the other, and this corporation keep bribing people to conduct. This is worse than the Watergate cover-up. They think we are stupid. You understand? So all these papers sent to the clerk of the court, so they have no record of my having wrote to the judge, to the chief clerk, Scott Harris. Okay? That's the name of the going on here. So now I've set all the legal machineries in motion. Oh, one more thing I forgot to mention, which is very important. After the first judge, Terry William Hodges, refused to conduct the proceedings because a judge cannot issue an interlocutory order and keep quiet. He has to do the next step, which he doesn't want to do. So when I reached my 65th birthday, I filed a claim for my ERISA benefits in New York. And in that action, I had included my action going on in Florida without any resolution. So the judge assigned to this was a woman by the name Giovanna Seibert of the Eastern District of New York. So as soon as the case is assigned, what the defendant did was, they went and secretly hired the chairman of the Democratic Party's Rules Committee. He's a partner at a major international firm called Fulbright and Jaworski. They changed the name recently because they merged with another British law firm, Norton Rose. So their full new name is Norton Rose, Fulbright and Jaworski. And this black guy, who is the chairman of the Democratic Party's Rules Committee. So when I filed a new lawsuit seeking my ERISA benefits from AT&T, which was, case was 063199 CV, assigned to Cybert and AKT. The defendant secretly or openly hired the law firm of Norton Rose, Fulbright and Jaworski by their partner Ralph Curtis Dawson. Who is a Columbia School graduate and a Yale or Harvard, I don't know, one of them. He is qualified to practice before the Supreme Court. He is a partner of the law firm. He is also a prominent member of the disciplinary committee of the New York Bar. As soon as I filed my case, Mr. Dawson came up with a motion to dismiss, like they do, without filing an answer. The motion was accompanied by a false affidavit from a person by the name Brian Wayne Tilker. Tilker is a newly licensed attorney, just graduated from St. John's University in New York. This idiot filed the papers. I'm going to show you the 4-page affidavit, sworn notarized affidavit, in which he stated, A, he has personal knowledge, mark the word personal knowledge, about myself executing a release in Detroit, Michigan on August 25, 1981. August 25, 1981. He says he has personal knowledge. He also alluded to a lot of things, how they managed to get a judgment from the Court of Appeals, which was denied by the Supreme Court. So as soon as this judge gets it, it's all political party game, because he is the chairman of the Democratic Party. This woman, Cybert, was appointed by Bill Clinton. So the justice system is now moving, not on an adversarial system, it's a political system. You kiss my ass and I do, you pat my back, I do likewise. That's the way they are running the system. This judge immediately issued an order, like the Tampa court did. No hearing, no trial, no discovery. These are the crucial things court has to allow. You got to permit the other party to submit evidence, obtain evidence from the opposite party. That's the purpose of discovery. No hearing. The case remained in the kangaroo courts of this woman, Cybert, for 7 years. No hearing, absolutely no hearing. Never these two lawyers, Dawson or Tilker, ever came to the court. You understand? They accomplished their mission through what we call the Charlie's Angels. They sent the money and the people, the angels, to accomplish their mission, so mission accomplished. Charlie never comes. You know, the Charlie's Angel television series. So, This woman grants a motion for summary judgment, 19-page order, citing Tilker's affidavit at least at 12 places for the basis of her decision. The Supreme Court says when there are triable issues of material facts remain in a case, no summary judgment can be granted. The issue before the court was whether the 2-page release is valid or not, for which the first judge decided to conduct a hearing, which they never did it during the last 37 years. So this woman, the cyber court, Eastern District of New York, grants a summary judgment. Citing Tilker's affidavit as the basis for granting a motion for summary judgment. Hey folks, I researched about this sucker, Tilker. Tilker was born on May 5, 1979 in New York. I signed the release August 25, 1981. So how old he was? 2 years old! 2 years child in his diapers, submitting to the federal judge an affidavit, sworn affidavit, you will see that, saying that he has personal knowledge. Did he have personal knowledge? Somebody 2 years old, living in New York, me executing a release that's 700 miles away from New York. Does he have personal knowledge, a 2-year-old kid? His affidavit was a clear case of perjury, telling the federal judge to believe what he's saying is true, and this woman is all game plan with the players, within the players, in the political party. Judge refuses. Mr. Tilker, now being an attorney, he can do so. He is submitting a false affidavit to the court knowing it is false. You understand? He knows what he is doing is under the direction of Dawson, who is the chairman and a member of the disciplinary committee of the New York Bar. I filed a complaint against these two, and that decision went to the Second Circuit Court of Appeals in New York. Second Circuit. Their bigger game, it goes again through political lines. It goes to a chief judge and 2 judges. Without reading my brief, without answering how the court can render a decision on the basis of a 2-year-old child, they affirm the name of the game here. Okay, everywhere you go, you affirm. It's the name of the game here. I filed a complaint against these 2 lawyers, one with two with the U.S. Department of Justice. The case goes to Preet Bahar, an Indian, who was the U.S. attorney at that time, which Mr. President Trump fired a few months ago. He says in his letter, these lawyers have not done anything wrong. We are talking perjury, for which there is a 5 or 7 year mandatory prison term. Okay, I have the letter of the Priest Bahara, which will be shown in a second, so you can understand what he is doing. I filed a complaint against these two lawyers with the Bar Council, New York Bar Council. George Dopico, its chief, files a petition before the Supreme Court of the State of New York, Appellate Division, claiming, since Mr. Dawson being a member of the disciplinary committee, we cannot take any action without prejudice. Okay, so he submits the motion. A 5-judge panel of the New York Supreme Court Appellate Division orders an investigation against Dawson. In an unpublished memo, which we are going to show, I put it on the Facebook before. So, they are asking another agency, which the New York Disciplinary Committee has been divided into 4 parts. Part 1, 2, 3, 4. So it goes to another agency for investigation as ordered by 5-judge panel. They conduct nothing. No investigation or hush up. So what I'm saying here, folks, everything is corruption. Corruption mill at its full swing. The Supreme Court don't get the facts. They don't investigate. The clerk of the court is in trouble because he failed to supervise or read what is sent to him. Another thing, which I again forgot, I filed a petition before the Supreme Court under Rule 22 of the Supreme Court Rules. 22 of the Supreme Court Rules, which read, I'm going to read it from here, Rule 22 of the Supreme Court Rules, for the benefit of the public. Application to individual justices. An application addressed to an individual justice shall be filed with the clerk, who will transmit it promptly to the justice concerned, if an individual justice has authority to grant the sought relief. Section 22, Rule 22, 2 says, the original and 2 copies of any application addressed to an individual justice shall be prepared as required by Rule 33.2 and shall be accompanied by proof of service as required by Rule 29. The Supreme Court rules here. US Supreme Court rules, 2017 is the latest one. So, they do not want this motion, the petition, to go to one of the justices. I addressed this to Neil Gorsuch, who was recently appointed. They don't want to give it to him. I suggested to the court, or the clerk of the court, alternatively submit to a justice assigned to the 11th Circuit, which is Clarence Thomas. They don't want to give it to him. You understand the name of the game? So this being controlled by the clerks of the courts, with the insiders bribing and this corporation paying them. Folks, this is not a good day for America. If these kind of things happen, and will continue to happen, sooner or later there will be mass murders in American streets. I hope you will watch my movie, one which we are working on, to show you what's the game going on in the United States. People have lost faith about the United States courts. It has become a kangaroo court rendering judgment based on politics. So the documentary is called The Fate of the Fate of the Dreamers. Fate of the Dreamers. So I'm a dreamer, came to America not through the back door, climbing the fence, but in a plane with my family. This is a fate. Hope you all will understand what is going on in America. Thank you for listening to me, gentlemen, ladies. എത്രയുണ്ട് 1.5 മണിക്കൂറുണ്ടോ?